Council Shive?
Yes, Your Honor,
Is
that's
that
unaffordable. Yes.
Thank you. Okay. Mr. Hamilton, okay. Bond is $20,000 cash surety. Somebody has to pay the equivalent of $20,000 to get you out of jail, but because it's unaffordable, sir, you're gonna get another court date this Friday, June 6th, 9 o'clock, in front of Judge McCoy, who's gonna look at the bond amount and bond conditions. Do you understand that, sir?
Yes, ma'am.
Thank you, sir. That concludes your arraignment.
Can I say one thing?
Sir, you do have the right to say something, but understand everything you say is being recorded and it can be used against you. Do you understand that, Mr. Hamilton?
Yes, ma'am.
Okay. So did you want to ask about the bond conditions, the court dates?
Yeah, I wanted to ask about my bond condition. I'll lose my job, man. I haven't been to work since Monday. These are all allegations. I never touched her, man. The blood on my
Well, sir, you don't need, all right, sir, you don't need to say anything else because that's something that's going to be dealt with the trial court, or at least at the preliminary examination or probable cause hearing. This court at this point found you a danger, sir. So we're going to leave the bond as $20,000 cash surety, okay, with a GPS tether. So even if I gave you personal bond, sir, you still have to sit in until they put a GPS tether on you. Do you understand that?
Yes, I'm aware of that.
All right. Well, good luck, Mr. Hamilton. That concludes your arraignment.
Jalil Bell.
Mr. Bell, this magistrate Charte, your criminal matter, is Jalil Tyrese or Tyrese Bell?
Tyrese.
Okay. Sir, your case number is 250-579-7601. You have an attorney. Go ahead, counsel.
Jessica Sheva on behalf of Mr. Bell is from a reading understands his constitutional rights and stands me.
Thank you. I'm going to enter plea of not guilty. Court dates are June 13, 2025, probable cause conference, followed by preliminary examination, June 20, 2025. Both matters are in front of Judge Shakay. Mr. Bell, let me give you some bond conditions. One, you're not to have contact with Asia Hendon. When I say no contact with Miss Hendon, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging, sir. You're not to possess any firearms or any other dangerous weapons, and you're not to go to the Saint Antoine residence. Do you understand that?
Yes,
Those
ma'am.
bond conditions, sir.
Yes, ma'am.
All right, Counsel Coyle, you're here on behalf of the people.
Good afternoon, Lisa Coyle, appearing on behalf of the people. Your Honor, Ms. Hendon and the defendant have a 3-year-old in common. My understanding is they do not live together. Allegedly, he became upset when she asked for some help and he began throwing items. Then he pushed her to the ground and assaulted her. He also allegedly grabbed a piece of wood and struck her about the knee and the ankle area. Officers observed a bump on her forehead, a bite mark on her right hand and neck, bruises on both legs, and the breast and shoulder area. Allegedly, he bit her hand when she tried to call the police. She went to Detroit Receiving for treatment, and I saw in a note that she has a broken ankle as a result of this assault. People believe he is a danger to Ms. Hendon. People are asking for, even though I don't see a prior criminal history, this is such a vicious assault that he broke her ankle a lot and also caused numerous bruises about her face and body. I'm asking for a $50,000 cash surety, a tether house arrest as well. And of course, no contact. Thank you.
Again, did you say 50? 50?
50.
Okay.
Yes.
Okay. GPS tether and house arrest or curfew?
I say house arrest on this one, Your Honor. Thank you.
Okay, thank you. Go ahead, Counsel Shive.
Your Honor, when the police arrive, they speak to my client first, and my client's story and the complaining witness's story are almost the same. They both almost say the same thing about the bottle, about him leaving, about him being upset, about her. She says he was upset as well. But he says that she attacked him first, and she even says in the report that she did grab his hair and she says it's self-defense. He says she attacked him first. We weren't there, but their stories are very similar, and he talks to the police first. When they arrive, they talk to him, and he tells them, you could see what he says. He admits to becoming upset, and he admits to throwing items in the kitchen, and he says that the complainant came downstairs, confronted him, and attacked him first. She says almost the same thing, but she says self-defense, and then she adds some things. He says she's lied before. He's not on probation or parole, nothing pending, no priors whatsoever. He's a lifelong resident, no capious history. He has somewhere else to stay. He did provide that address. He is working. He provides for his child with that job. So I'm asking the court to consider a personal bond instead of a cash bond. And if the court is not inclined to do that without a tether, then I ask that he be allowed to go to work, Your Honor. That will at least ensure safety to the complaining witness, but he has no priors, nothing pending, and these are allegations.
Thank you. Court's heard the representations, both sides. Court uses clear and convincing evidence standard when it's entertaining monetary bond. The court is entertaining a monetary bond. Let me start off that another bond condition is that Mr. Bell is going to be placed on a GPS tether, work only. I heard the representations. I read the allegations. If they're both fighting against each other, physical fight, at some point, okay, I don't know where, but allegedly says that Mr. Bell grabbed a wood from a painting easel and struck the complainant on the ankle and knee, and she's got a broken ankle. So I'm not sure when it went from physical to having physical with, okay, some sort of object in this matter. Does say that the complaint indicates she grabbed the defendant's hair, self-defense. However, if they were both using their hands or their feet, whatever it was, at one point, this escalated from person's hands and feet to the use of an object. So this court does find that Mr. Bell is a danger. Court is not going to go with $50,000 cash surety. Court is going to go with $25,000 cash surety. Counsel Scheib, is that unaffordable?
Yes, Your Honor, that's unaffordable.
Okay, so Mr. Bell, that means that this court meeting I is not the last word. You're going to get another court date this Friday, June 6th, 9 o'clock in front of Judge McConico. He's going to look at the bond amount and bond conditions. Do you understand that, sir?
Yes, ma'am.
Okay, that concludes your arraignment, sir. You can step aside.
That was 25,000 cash.
The surety.
Thank you.
How you doing?
What's your name, sir?
J9 Andrews.
Thank you, Mr. Andrews. I'm Magistrate Charte here, criminal matter. Case Javon Henry Andrews.
Yes, ma'am.
Your case number is 250-579-7901. Counsel Scheib, you wait for more reading, stand mute.
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are June 17, 2025. Probable cause conference followed by preliminary examination, June 23rd, 2025. Both matters are in front of Judge Taylor. Mr. Andrews, you got a couple bond conditions. You're not to possess firearms or any other dangerous weapons. You're not to possess any type of ammunition. Do you understand those bond conditions?
Yes, ma'am.
Counsel Vincent, go ahead with your argument.
Thank you, Magistrate. It's Steve Benson for the people, P71917. Yeah, Magistrate, this is another one of those where I don't even have to appear. That was the condition I was going to be asking for. No objection to a personal with that condition.
Okay, all right, Mr. Andrews, your attorney hasn't said anything, so I know she's gonna be asking for a personal bond. You're gonna get a $25,000 personal bond. The prosecutor's not objecting. Nobody has to pay any money for you to get out of jail. You understand that, sir?
Yes, ma'am.
Okay, good luck, sir. You can step aside.
Thank you.
Sure. Let's see who we have here. Uh, Okay, Counsel Upshaw.
Yes, Your Honor.
Okay, now, the gentleman at DDC, what's your name?
Mayor Walker Oaks.
Jamel Andre Walker Oak, sir?
Yes.
Sir, I'm magistrate at there. Your case number is 25057975001. You have an attorney, Counsel Upshaw. Counsel Upshaw, what's your P number, sir?
43574.
Thank you, sir. Counsel, do you waive formal reading, stand mute?
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are June 13, 2025, probable cause conference, followed by preliminary examination, June 18, 2025. Both matters are in front of Judge Giles. Mr. Walker Oates, while this case is pending, you're not to possess any illegal, cannot use or possess any illegal controlled substances. Do you understand that, sir?
Yes, ma'am.
Okay. Counsel Coyle, go ahead, ma'am.
Good afternoon, Lisa Coyle, appearing on behalf of the people. Good afternoon, Mr. Upshaw. Your Honor, this matter is a 50 to 449 case. I have no objection based on the fact this is 160 pills of fentanyl allegedly, just over 50 grams. The problem is what's surrounding the finding of the drugs is that the officers understand that Mr. Walker Oates is in an auto accident with another, and he responded, he told the officers, by firing shots at that SUV. He's not charged with any of that, Your Honor, but this is all allegedly happening around a drug house in which it sounds like he may be selling out of that drug house. So for that reason, Your Honor, noting that he is not charged with any of the shooting or any of those allegations, but somebody did get shot that was waiting to buy drugs from that house. I do note that it doesn't appear to be his residence, but maybe a home that is used, and he may be part of the selling of drugs based on the quantity he has. No one was being truthful to the officers regarding the whole instigation of the shooting. So based on that, long story short, people have no objection to a high personal bond, but I am asking for a tether, work only, and that this is one of those situations where dealing drugs does have an effect here. It always has an effect on the community, but based on the fact this is a dope house, there's a shooting that's going on outside of that dope house. Somebody there to buy narcotics is got shot. He does have a prior history as a 2011 armed robbery conviction. And for that reason, that is why I'm asking for the tether, work only. Thank you.
Thank you. Mr. Walker Oates, one other bond condition. You're not to possess firearms or any other dangerous weapons. You understand that, sir? I didn't hear you.
Your Honor,
Thank you. Go ahead, counsel.
just a brief response. I have the utmost respect for Ms. Coyle, but there's a lot of things different and a lot of speculation going on there. And my client was not arrested inside of that vehicle, and he was not arrested. He does work at Chrysler. I have no objection to the tether, of course, wants to place tether. But I based on these facts, and he hasn't been charged with a case in the last 14 years, I would ask you to just put tether for monitoring purposes as opposed to home confinement. He works 12 hours, a lot of times at Chrysler. He has a family, he has a child he has to take to school, and he hasn't been even charged in the last 15 years. Thank you, Judge.
Your Honor, I did not ask for home confinement. I did say work only. I'm sorry if I did say otherwise. I thought I said work
Okay.
only.
No,
Sorry.
that's all right. GPS tether, work only. He's gonna get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail, Mr. Walker Oates. Do you understand that?
Your Honor, when you say work only, maybe I'm not, does that mean he can only go to work? He can't go anyplace
That is
else?
correct. He can only go to work.
Have a good day, Your Honor.
Thank you.
Excuse me, Your Honor, because I don't know how long it is. Is it possible so he can get back to work? You can allow him to have the EMS put the tether on him, because the Wayne County might be taking a long time.
I'm just gonna leave it up for Wayne County, sir.
Have a good day, Your Honor.
Thank you, though. You have a good day. Okay, that concludes the arraignment of Mr. Walker. Oaks. Okay, thank you. BDC, that's it for you?
Yes, ma'am.
You have a good day. Okay. Do we have Mr. Robinson? Mr. Robbins, come on forward. Sir, what's your full name?
Martinez Michelle Robinson.
Thank you, Mr. Robinson. I'm Magistrate Chartea. Your case number is 24057128001. Thank you for walking in. You have an attorney, Counsel Shive.
Yes, Your Honor.
Oh,
Jessica Chuck, on behalf of Mr. Robinson, who is formal reading and understands his constitutional rights and stands here.
thank you. I'm gonna enter plea of not guilty. Court dates are June 11, 2025, probable cause conference, followed by preliminary examination, June 18, 2025. Both matters are in front of Judge Robbins. Mr. Robinson, you're not to possess any firearms or any other dangerous weapons. You understand that, sir? Okay. This is from April 2024. Counsel Coyle, go ahead with your argument.
Lisa Coyle appearing on behalf of the people. No objection to 5,000 personal.
Okay. Mr. Robinson, you're gonna get a $5,000 personal bond. Had you been sitting in jail, nobody would have to pay any money for you to get out of jail. So we're just taking you at your word that you're gonna come to court and obey the bond conditions. You understand that, sir? So do me a favor, take a seat, wait for your paperwork. Thank you, sir. All right. Mr. Eggleston, come on forward. Please say your full name, sir.
Leon Eggleston Jr.
I'm sorry, what's your full name?
Leon Eggleston Jr.
Why do I have a Bernard in here?
Leon Bernard Eggleston Jr.
Thank you, Mr. Eggleston. Sir, I'm Magistrate Chuck Thiers. You've been sitting here. Your case number is 250-5789101. You have an attorney. Go ahead, Counsel Davis.
Morning. Well, afternoon, Your Honor. Maurice Davis, P76203, appearing with Leon Eggleston. I'll waive formal reading of the charges and a plea of stand mute.
Thank you, sir. I'm going to enter a plea of not guilty. Court dates are June 17, 2025, probable cause conference, followed by preliminary examination, June 24, 2025. Both matters are going to be in front of Judge Taylor. Understand those court dates, sir?
Yes, ma'am.
Okay. All right.
Good afternoon.
Counsel Coyle.
Good
Yes,
afternoon,
ma'am.
Lisa Coyle appearing on behalf of the people. Good afternoon, Mr. Davis. This is
Afternoon.
non-assaultive, Your Honor. No objection to a 5,000 personal.
Thank you. With that being said, Mr. Eggleston, you're going to get a $5,000 personal bond. We're taking you at your word that you're going to come to court. You're going to obey the bond conditions, correct?
Yes, ma'am.
Okay. So now all you have to do, sir, is take a seat in the audience, wait for your paperwork.
Yes, ma'am. Thank you.
Hey, Your Honor, I
Thank you.
would ask for permission for him to leave the state. He lives in Ohio.
Counsel Coyle, any objection?
No, Your Honor.
Okay, all right. Sir, are you allowed to leave the state of Michigan to Ohio? That's your place of residence? Okay, so you're allowed to go to Ohio. Okay, I believe that concludes the arraignment of Mr. Eggleston.
All right, thank you.
Thank you. All right. All right, Counsel Coyle, that's it.
Thank you. Have a good evening, everyone.
Magistrate, thank you for this docket. It was like a present, so I appreciate it.
Okay, take care,
Take care.
folks.
All right.
All right.